Hi, my name is Sonia Kim, and I'm the Marketing Manager at the Innovation and New Ventures Office. Welcome to INVO's new video series. Here at INVO, we manage Northwestern's inventions, including their disclosure, assessment, patenting, marketing, and licensing. Many of our office's activities focus on helping to move your research along the commercialization path so that it can eventually benefit the public. These videos may be particularly helpful if you're unfamiliar with what we do at INVO. But we understand that our work can often appear complicated, so we've created this series to help demystify some of our processes. We'll introduce some vocabulary commonly associated with patenting and licensing, help familiarize you with the key steps in commercialization, and offer some best practices that can help facilitate and perhaps expedite your experience with us. In the end, we hope these videos help make our processes as smooth as possible for you. INVO invites all Northwestern inventors, veteran, novice, or anywhere in between, to watch these brief videos. In this first one, we'll talk about the invention disclosure process. More specifically, we'll cover the following topics related to disclosing an invention to our office. First, what is an invention disclosure? Why should you disclose to the university? When should you disclose? How do you disclose an invention? And finally, what should inventors expect after disclosing to INVO? So first, what's an invention disclosure? An invention disclosure is a record of an invention, the inventors involved, sponsorships, and other public disclosures. To help clarify our office process, here's a simplified flowchart. Once a disclosure is received, it's assigned an NU docket number, and then evaluated by one of our intellectual property associates. With the help of our in-house patent attorneys, the invention managers, also called IMs, will decide whether to file a provisional patent application as a placeholder. Northwestern has 1 year to convert this provisional into a utility application. The U.S. Patent and Trademark Office, also known as the USPTO, will then evaluate the utility application and decide whether to allow you to claim aspects of the technology as your own invention. If the USPTO allows some of your claims, then those aspects of your technology become patented and protected. You should know that submitting an invention disclosure to our office does not mean that your idea automatically becomes protected. If you wish to talk about your invention with others, and you're concerned about confidentiality, contact INVO. An invention manager will help get a confidentiality agreement, also known as a CDA or NDA, in place. Please note that you may not sign a CDA on behalf of the university. Only authorized individuals may sign, because if the agreement is breached, you'd be putting yourself at risk. It's probably important here to point out that an invention disclosure differs from a public disclosure. When we talk about an invention disclosure, we're talking about formally disclosing your invention to Northwestern University through INVO. An invention is considered to be publicly disclosed when it falls into one of these four broad categories. 1. Printed publications. Inventions that have been described in printed publications such as journal articles or book chapters would be considered publicly disclosed. This may also include email correspondences, grant proposals, posters, abstracts, proceedings, and also oral disclosures at conferences, departmental seminars, and the thesis defense. 2. Inventions used by the public. If any invention is used by the public, such as research materials or prototypes, they would be considered publicly disclosed. But this does not include materials if they are provided for testing or evaluation, or if they're used for research purposes under a written agreement. 3. Inventions on sale. This would include inventions if there was a sale or an offer to sell. And lastly, any invention that is otherwise available to the public would be considered one that has been publicly disclosed. Why should you disclose your invention to INVO? These are probably the top 4 reasons. First, by disclosing to the university, INVO may be able to better protect the commercial potential of your technology. Of course, disclosing to INVO doesn't guarantee protection of your invention, but it can lead to protection if we file. We can also provide feedback on how to best proceed in the commercialization process and help make connections with our investor and industry contacts for further input. With this information, IMs can accordingly structure patent applications. Second, If IP protection is appropriate, INVO can file U.S. patent applications on your behalf and can also maximize protection by coordinating application filings in accordance with varying international laws. By disclosing earlier, we can seek international protection if needed. Sometimes inventors don't disclose to us until after they've publicly disclosed, at conference talks or publications. And even though a U.S. patent may still be possible, international protection is not. Third, disclosing to INVO helps to fulfill Northwestern's legal responsibility to report commercial activity as a result of public and private research grants. Most grants, whether from government organizations like the NIH or NSF, or non-government organizations, legally require notification of the development of an invention as part of the funding agreement. Reporting allows Northwestern to continue receiving sponsorship for future research projects. And lastly, submitting your inventions will help INVO market your inventions better. In addition to properly recording the invention, we can also talk about specific faculty, their research, and available inventions as we meet with investors and contacts in industry. When should you disclose? Ideally, we'd like you to plan to submit your disclosure to INVO about 3 to 4 weeks prior to your public disclosure. If you're within that time frame, please contact INVO as soon as possible. Something that may help time the disclosure process is to engage INVO as soon as possible. This includes those times when you're not sure whether you have an invention to disclose or not. We'd like to encourage regular dialogue between faculty and their respective invention managers. So if you don't have an IM, please contact our office and we'd be happy to connect you with one. One thing to consider is to invite your IM to periodic lab meetings. IMs can provide guidance with respect to their timeline for disclosing and patent filing, as well as what types of work may be required before filing a patent is feasible. Another factor to consider in the timing of the disclosure is that the U.S. recently passed a new patent law called the America Invents Act, or the AIA, which came into effect in March of 2013. The U.S. now follows a first-to-file system, which means that the inventor who files their patent application first with the USPTO will have the right to claim an invention. In other words, if two inventors independently invent the same idea, it no longer matters who actually invented it first. Whoever files with the USPTO first will gain priority. However, there are some circumstances that can overrule this scenario, but this topic will be covered in our next video on patenting. And while filing too late is a problem, filing too early is not always the best solution as well. The key here is to begin discussions with INVO early, and when in doubt, contact your IM at INVO. The invention disclosure form is occasionally updated. The most recent version is located on the INVO website. Visit www.invo.northwestern.edu. On the right side of the page, click on Forms under the head of Inventors. The invention disclosure form is the first listed on a variety of downloadable forms. By clicking on this hyperlink, you can download the form as a Word document. Please note that if you're disclosing source code, use the software disclosure form. And if you have literary or artistic works, please complete the copyright disclosure form. For those of you who are not yet familiar with the parts of a disclosure form, I'll briefly go through each section. The first thing to note is that all fields can be entered by clicking and typing directly into each space. Once you enter your invention title, please enter all inventors. Sometimes there's confusion between authorship and inventorship. Authorship may be given to individuals who contribute to a particular paper in the form of discussions, data, or results. An inventor, however, is someone who contributes to the conception of an idea. It's important that inventorship is properly recorded. If inventorship is found to be inaccurate, the entire patent, though rare, can be legally invalidated. Please talk with your IM to discuss any issues regarding inventorship. And regarding the Northwestern School and Department designation, please list your current affiliation, not your affiliation when the invention was originally made. In the next section, for sources of funding, INVO requires accurate reporting of your sources of funds. The grant numbers are sometimes not accurate, which creates additional work to follow up with you and sponsors because numbers are missing or switched. Please also note the various fields for grant information and the additional space if a subcontract is relevant. This will enable us to report commercial activity to your sponsors accurately. For the marketing space, based on the fact that you know your invention best, we ask you to describe your invention in the space in a less technical manner. What's the relevance of your invention in the real world? What are possible applications? What are the advantages of your technology, particularly if there are similar products already on the market? In the next section, we ask for a more technical description of your invention. This information allows our intellectual property team and outside counsel to better understand how your invention is distinct from other inventions. We ask you to list relevant public disclosures in the next section. In the discovery information section, please include details of your discovery. Answer the when, where, and how questions. Regarding the prior art section, while the INVO IP team performs its own prior art search, if you are aware of inventions that are somewhat similar to yours, this would be a great place to mention those. It will allow the team to differentiate your invention from others. The commercialization section. Again, since you're most intimate with your invention, your input is a tremendous asset as we determine the best commercialization pathway for your technology. Knowing your insight into what commercial problem your technology solves, which companies might be most interested in your technology, and whether there are products that are similar or relevant will all help develop a commercial plan. In the last section, please provide complete information for each inventor. It will expedite the disclosure process. Interestingly, among the sections of the disclosure form, this section is often left incomplete, which holds up the ability for us to process the form. Please take care to enter this section thoroughly. We also need complete address, phone numbers, and the requested contact information. Even your citizenship must be noted. This information allows us to confirm your identity, and in the case when a licensee is identified, we'll know where to send distributions. All Northwestern inventors must sign the form. We're now allowing electronic signatures by inserting a scanned signature or by typing your name in the signature box. Once you've completed this form, please send it to invodisclosure@northwestern.edu. Once you send in your completed disclosure, INVO will evaluate it. Why does INVO need to evaluate disclosures? Well, the first thing that INVO must do is to make sure that the invention meets the guidelines of the USPTO in terms of the definition of what is patentable. All inventions must be new, useful, and non-obvious. So why doesn't INVO patent all submitted disclosures? There are many factors that weigh into our decision on whether to apply for a patent. This occurs at a couple of times. One is at the time of filing a provisional patent application. The second time is a year later when a decision needs to be made as to whether to convert the provisional into a utility application. Here's a list of some of the things that we take into consideration as we evaluate new inventions. First, not all inventions are eligible and are ready for patenting. Typically, if this applies to an invention, we would not file. For example, the USPTO will not patent mathematical equations or abstract ideas that are not implemented in any way. So, if someone submits something that falls in these categories, INVO would not file. As for being ready to patent, disclosures must meet the required threshold of data for filing, which basically means that if you have insufficient data at the time of the provisional, it would be probably better not to file. For example, you may file a provisional in 2013. 1 year later, your provisional may be converted to a utility application. If you add new data to the utility application that's significant enough for the USPTO to notice is different from the provisional, they would take away your 2013 priority date, and your new priority date will be based on your utility application, 2014. A worst-case scenario is if another inventor files between your provisional and utility, they would be granted an earlier priority date. The second reason is that not all inventions may be commercialized. Though there are exceptions, in general, Northwestern would like to file patents on inventions that can become a product or be incorporated into a product and then ultimately be licensed. Please keep in mind that some inventions can actually be commercialized but not need a patent. 13% of the technologies that have been licensed are not patented. Of those, 53% are research tools like mice, antibodies, cell lines, and reagents. 38% are software. 6% are copyright, and 3% are methods. Third, INVO will try to determine whether there's a market for a potential product. While Northwestern does not require that there be a sizable market, it's something to consider in our decision-making process. Fourth, INVO needs to also consider whether there are significant regulatory hurdles associated with an invention that are prohibitive to commercializing. While this alone would not prevent a patent from being filed, it's something that the invention manager must also take into consideration as well. And finally, the cost of patenting is not insignificant for the university. U.S. patents cost between $25,000 to $30,000, and foreign patents can be over $100,000. INVO's budget is finite, and while it would be great to file on everything that comes through our door, we must determine to the best of our ability and on behalf of the university which inventions have a great chance of being licensed and ultimately making it to the public as a commercialized product. A really important note that INVO would like to stress is that if we decide not to file on an invention, it does not reflect the scientific merit of the invention. If you're interested in knowing more specifically what factors INVO uses to determine whether an invention is patentable or not, you can access our disclosure assessment form on INVO's website. Just to give you a sense of how we evaluate inventions, this slide lists a sampling of questions that we ask. You may hear IMs talk about prior art. Prior art refers to previous ideas that have been patented or publicized. Once you disclose to our office, we will search for any past inventions or publications that look similar to your invention. So why do we search for prior art? We do it preemptively, knowing that the USPTO will do the same. Once a patent application is filed, the USPTO will respond in an office action by citing all patents that they have found as evidence against your patent application. If INVO files prior art ahead of time, you can let us know why your invention is in fact different from what's already out there. And based on that information, our patent attorneys can better structure your patent application so that it's more clearly differentiated from previous inventions. Alternatively, if we identify prior art that's actually too similar to what you've disclosed, we'd be able to save time and money from filing on something that would ultimately be rejected from the USPTO. You may also hear the terminology patent claims. What does this mean? On an invention, you'll naturally want to claim your invention in its entirety. But attorneys actually have to break down your invention into individual elements, or what they call claims. Some patent applications have a couple of claims, and others have many pages of claims. But by dissecting your invention into these individual elements, the attorneys try to protect parts of your invention if the entire technology cannot be patented. The claims can be more general and cast a wide net. These are considered broad claims. Or, on the other hand, if there are already a lot of patents out there, you may only be able to carve out a little piece that is unique to your invention. This type of claim would be considered narrow. In reality, though, many times the USPTO will allow you to claim certain aspects of your invention as your own, but not all of them. Another factor to be considered in an invention assessment is the stage of the invention. If it's disclosed too early, there may not be enough data for the patent application. I've described one reason already for this a couple slides back, but the other reason is that the USPTO requires that the patent contains sufficient details for anyone who's familiar with your invention area, otherwise known as someone skilled in the art, for that person to be able to recreate your invention. This is the definition of an invention being enabled. INVO will also explore how your invention can be made into a product. Northwestern would like to seek inventions that can become a product or be incorporated into existing products, as these characteristics will increase the chances of our being able to license them. We'll also explore the market for the technology. If there's a small number of people who'd be interested in using this invention, there isn't a large market for the technology, and it would be difficult to generate revenue from the invention. It may be hard to convince investors to invest in this technology, and companies typically don't want to be in a market if there's a small customer base. If a market's really saturated with potential competitors, it may be difficult to enter or penetrate the market. However, if there are clear advantages or desirable distinctions over others, these would be features that INVO would take into consideration. INVO has connections with industry and investors, so we're able to seek feedback in a non-confidential way. So in the end, many of these factors help INVO to make a go or no-go decision. It can be a complicated process, and to be truthful, sometimes a difficult one, but the invention managers will make the best decision they can based on the data surrounding each invention that's disclosed to Northwestern. Once a disclosure is sent to us, it falls into one of several buckets. It may be ready for patenting, it may require more data, or it may not be patentable for various reasons and may be archived or released to the inventors. For those inventions where more data is needed, they may go through a second round of evaluation. Once more data is received, a decision is made to patent or archive the invention.
INVO continually evaluates an invention's potential and can decide at any time to release the invention back to the inventor or inventors. In these cases, when INVO releases inventions, the inventor may wish to seek ownership of the IP. You may need to receive approval from your research sponsor for the transfer of ownership from Northwestern to you. INVO would be able to help you obtain the correct waiver for approval.
What are the responsibilities of an inventor? What can you do to help the patenting and commercialization process? First, complete the disclosure as thoroughly as possible. It will decrease the back and forth between our office and you. Second, please make yourself available for meetings with INVO staff. Once the disclosure is submitted, your IM may want to discuss the technology in greater detail. Third, IMs partially serve as liaisons between you and the USPTO and patent attorneys. Please respond to their questions, as some of them may be time sensitive. And finally, please send relevant updates to IMs, such as future publications, technology developments, or interactions with companies independent of INVO. If you have any questions, please contact INVO at info@northwestern.edu. If you're new to INVO and would like an invention manager, please contact us. We hope you enjoyed our first video. Stay tuned for our second video, which will cover the patenting process. Thank you.